Turn to the second case on this morning's docket. That is case number 105962, City of Lincoln Center v. Farmway Co-op Inc. and Farmway Storage No. 1, LLC.
Please the court, Daniel D. Metz, City Attorney for the City of Lincoln Center. First of all, I want to thank the court on behalf of the city for granting our petition for review and for taking the matter under review. I would reserve 3 minutes for rebuttal. I assure the court I won't use it unless I feel I need to, but I would take 12 on my argument and reserve 3 if that's permissible.
That is granted.
I realize that the facts have been before the court, very limited facts, I might add, because as the court is well aware, when there's an appeal from the municipal court, and incidentally our municipal court made extensive findings, is a law-trained lawyer judge, as are all of our magistrate courts in the 12th Judicial District. And those facts, of course, are not before the court. Just a little background, as opposed to facts which you do have from the briefs to the extent that they are present. The matter was charged in Lincoln Center under egregious circumstances. Certainly, there is no, I want to dispel at the outset, there's no problem with the City of Lincoln Center and the farming community and the Farmway Co-op business. We strive to get along, and we do get along. I have Farmway gas in my car. We have no ongoing thing, as the amicus briefs may have suggested to you. The first point I want to make on appeal is one that I think is the crux of our argument. This was a summary dismissal. The district court had the duty, all of the authority that you're well aware of, that you've seen in all of the briefs, start out by saying that a constitutionality of a statute is presumed. The district court had the duty to attempt to do what the district court could do to uphold the statute. That's the law. The Court of Appeals said that in their very initial syllabus. And if there is any reasonable way to construe a statute as constitutionally valid, that should be done. Well, the court didn't give itself the opportunity to do that by summarily dismissing not only the noise ordinance complaint portion, but the nuisance portion, which came right out of the Uniform Public Offense Code and the Statute of Kansas, which incidentally, as I will point out, I'll just briefly mention it now because I want to come back to that with at least half of my time to talk about the nuisance ordinance. But and I want to point out a couple of other things that the Court of Appeals said in its initial statement. Under the facts of this case, inclusion of the word unreasonable in the city's ordinance does not cure its vagueness. Well, there were no facts that the court had because it was a de novo case. Under the facts of this case, the Court of Appeals went on to say, even if the city is correct that its ordinance is distinguishable because the inclusion of unreasonable, which is not in the Luna ordinance, as you've read in the briefs, not even in the Wichita ordinance. And I'll talk about the reasonable sensibilities framework, which you perhaps have questions on. But the distinguishing features of the ordinances are well brought forward in the briefs, and I'm not going to dwell on them, but there are key words in the Lincoln ordinance that don't appear. Injures, endangers, health, safety, injuring, endangering. Those are all standards that are acceptable. But the point is that the district court, under the de novo concept to which it was bound, and which we were all bound, did not let itself search as it needed to do to find a way to uphold the Lincoln Center ordinance. The reasonable sensibilities test. That came forward in the Luna case, which is cited in all of the briefs. Unreviewed, I might add, not by this court, by the Court of Appeals. The Court of Appeals' way of handling that was that the Lincoln Center ordinance, the ordinance that I'm here to urge you to uphold, or at least send back so that the district court can perform its duty by pursuing a way to find it if it's there, said we're somewhere in between. I thought this was an interesting statement, and it may be one of the reasons that we're here today discussing it. How can we be in between? The Luna case had none of the words, standard words, that the Lincoln ordinance had. The Smith case out of Wichita was upheld because they adopted the reasonable sensibilities test. But the Lincoln ordinance, standing on its own merit, did not need the reasonable sensibilities test. And even if it did, I urge this court in its review to consider whether it can be applied across the board as the magic wand of all ordinances that cities might present to you in the state. And I submit that it does not. The reasonable sensibilities test can apply in certain cases. Certainly it was appropriate, I think, in the Luna case. We could have had none of the standards that the Lincoln ordinance had in it.
Mr. Metz,
Yes.
I guess talking about the noise ordinance in particular for a minute, I guess I just don't see anything, putting aside the Luna case and the Court of Appeals cases, just looking at this statute, I just don't see anything in it that has any kind of objective standard. It uses words excessive, unnecessary, unreasonable, or unusually loud noise, which either annoys, disrupts, injures, or endangers the comfort of blah, 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 others. And then it uses that word others, not a reasonable person, not anything that has anything, not reasonable sensitivities, just the word others. So who gets to decide this?
Your Honor, in this case, the only case that's before the court, the city brought the charge through the chief law enforcement of the city, the sheriff, who is under contract with the city to provide law enforcement. This is not a neighbor. This is not, there were 52 neighbors, actually, that complained to the sheriff.
That's not what I'm asking. Who are these others within the city? I assume it's anyone within the city limits who hears a noise, who is disturbed by it.
Well, in this case, Your Honor, there were 52 people who signed a petition. These are the others that you're asking.
Well, no, I'm not looking at the facts right now. I'm asking, under the statute, what is there about it that gives a person any idea which of their activities might be subject to regulation under this statute?
Injures, Your Honor. The word injures is there, not in the Luna statute.
No, well, it is there, but there's a lot of words there. That's my point. And there's no objective standard
Well, Your Honor,
from which to look at those words.
But if a person is injured, or if a person is endangered, or their health is injured, why is that not a standard? And the point of...
Excuse me, counsel. Those are fairly particular. The one that's really troubling me is a noise. Because, for example, I don't share the same musical taste as some, and vice versa. And I could imagine I'd annoy them by playing it, which might be unnecessary.
Your Honor, in the facts of this case, had they been developed, we would have found that the word annoy isn't needed. Annoy appears in nuisance statutes all over the country, but that doesn't mean it needs to be upheld. They are severable, and I've argued that in one of my reply briefs. And this is the point that the court never addressed. The summary dismissal prevented the district court from taking into consideration the words that were in the Lincoln Center ordinance.
So in
and
other
there
words,
are severable, and one can be severed.
So in other words, the charge, it's your position that the charges in this case, at least as to the noise ordinance, the charge didn't rely upon annoy or unnecessary, kind of those vague terms. It relied on more concrete terms in the statute, and that should save it.
Excuse me, Justice Breyer.
And that should save it, that those other terms that you view as more concrete should save the whole statute.
That's what we submit the court should have examined rather than summarily dismiss the ordinance, because they are severable. Now, the complaint...
But there is a difference between as applied and facial vagueness, and if it is facially vague, then the judge didn't need the facts of the case, right?
Well, I submit, Justice Johnson, that the court did need to, because there isn't a single case in any of these briefs that I have submitted that did not have a hearing of some kind, a trial. There was no trial in the District Court of Lincoln County, Kansas. And to respond directly to your question, the applied, which the defendants have attempted to bring in belatedly, I would submit, but nevertheless they have, that's after the facts have been considered. Now, there were no facts applied because the court summary dismissal of the charge. The law is clear that if the contention is vague, you still have to search for a reason to uphold the ordinance. And you don't do that by summarily dismissing.
I'm not sure I'm following. Are you saying that we cannot consider this as a facially unconstitutional statute? That we always have to consider it as applied?
Oh, no. They didn't get to as applied in this case because the court dismissed it on vagueness. I'm going to cover that, Justice Luker. If I could move on just briefly to the nuisance, because I haven't said anything about that, and I feel that I should. And if I can maybe cheat a little bit on time to throw my nuisance argument at you, which will be somewhat brief but speaks for itself. We have the nuisance portion of our ordinance came directly from the League of Municipalities, UPOC, Uniform Public Offense Code, which is exactly the statute that was reenacted in 2010 and is found at KSA 6204, which is maintaining a public nuisance, which is exactly what the city UPOC ordinance is. And that was reenacted just in recent time. And I notice also in looking at that the 216203 talks in terms of disorderly conduct, engaging in noisy conduct, tending reasonably to arouse alarm, anger, or resentment. That's a statute that's on the books. It's no different than the one relative to nuisance. And we would submit, Your Honors, on the nuisance issue that there needs to be examination. The whole body of law has been ruled unconstitutional by the District Court of Lincoln County. Over 300 cities use the Uniform Offense Code. The state uses it. It's part of our statutory law. And we would submit that the court could either find that it's not invalid because it's under the responsibility of a city to look after the welfare, safety, and health of its citizens. And the Home Rule Amendment, of course, carries that even further. So,
Counsel, could you refresh my recollection for me?
Yes.
Has any court either said that KSA 216204 is not constitutionally vague, or has any court ever said Uniform Public Offense Code for Kansas City sections 9.5, 9.6 are not unconstitutionally vague.
I know of no decision there, Your Honor. And I submit that with home rule, it's even more binding, and it covers what the common law says a city has to do. And that's what the city did do in this instance. I see my time is up, but I'd be happy to have another question if anybody.
Yeah, I've got one if I may.
Sure.
Because you mentioned the home rule there at the end, and in some of the amicus, there was also a notion that the home rule provisions in the Constitution was somehow relevant, and I'm having trouble even accepting that, because if the issue is vagueness, why would you get any more leeway because we have a home rule provision in our law than otherwise? I mean, it's either going to be constitutional or it's not. I don't understand why home rule is relevant.
Well, home rule, I assume it's broadly referred to because it was a speaking of the people. It gave the cities the constitutional right to handle their own affairs. Now, how it directly involves vagueness, I think the vagueness issue is the duty of the court to attempt to uphold, and in this case, it was a summary ruling of vagueness.
Well, you don't think the city can be more vague because of home rule than the legislature can be?
I'm not going to argue that, Your Honor, no. And the other thing is, I think this court should look carefully at I think the Court of Appeals certainly set up by saying we were somewhere between Luna and the Smith case, that it needs to be examined and the distinctions need to be pointed out. Thank you very much.
And speaking of those two cases, what would be the case that you think is your best case to support your argument on
I'm
either one of
sorry,
these?
Your Honor.
What is, in your opinion, the best case you have to support your argument today?
I think the best case, Your Honor, is the Hofstadter case, certainly on the nuisance, and it's quoted, of course, part of the petition for review had to include the city municipal court's ruling. That Hofstadter case was quoted at length, and that would be the strongest case that I believe supports the city's position relative to nuisance and self-government with its noise ordinance.
And what would be your strongest case for the noise ordinance?
That would be the same to some extent, but the cases that we cited in the beginning of our brief, and I don't have the brief, but they're the ones that require, before a vagueness determination can be made, that the district court or the trier of fact search for a way to uphold it. Now, the Smith case in Wichita, of course, supports a finding in favor of the city, but it also used the reasonable sensibilities test. I would ask this court, and I've already said this, and I don't want to be repetitive, that in responding to what the Court of Appeals said about being between the two, the reasonable sensibilities test should be examined. It was not, to see if that can be applied, if those are just magic words. And to me, the district court found those magic words and threw them in, didn't go anywhere beyond that. They're not just magic words.
My understanding is that reasonable sensibilities, that language actually appeared in the ordinance that was at issue in Smith.
In Wichita it did. It did not appear in the Luna case.
Correct.
Yeah, and it was not in the Luna ordinance, it was not in the Lincoln ordinance, it was in the Smith ordinance, but they're different facts, and I think the facts are important in any of these cases.
Okay. Justice, I'm sorry, I didn't mean to interrupt.
No, I'm fine with that.
I was just going to ask, I guess I didn't understand Judge Cuddy's opinion to say that it had to use the words reasonable sensibilities. I understood her opinion to say that you had to have some sort of an objective standard, which is lacking from this noise ordinance.
She dismissed the fact that, and even in her opinion, she didn't say anything about injures, about unreasonable. She said, like you did, the annoy was
Right.
important to her.
Well,
And they're not what the city's relying on.
but when she was talking about the reasonable sensitivities language, which you'd mentioned, she was talking about that objective factor that would apply to all of those words, not singling out any one word.
This is where we respond by saying that this was a complaint not filed by the citizens themselves. This was a complaint after investigation by the Lincoln County Sheriff.
Well,
I think this makes
again,
a
I
difference.
guess it's a facial challenge, so I'm not really concerned about the facts, and I think that's why Judge Cudney wasn't concerned about the facts. I understand your argument about the facts, and I read Judge Grace's opinion where he set out all the facts, but those facts don't pertain to a facial challenge, which you agree that this is.
Well, it was a facial challenge that was summarily accepted without development of facts that I believe were essential, along with the differences in the ordinances. And those were not taken or given any weight by Judge Cudney.
Are you conceding that some of the words of the statute are so ambiguous that they couldn't be
Well-
applied? So we should just go through and strike those words and then leave any words that can be objectively applied?
I've argued that, Your Honor, I think in my reply brief to the supplemental brief that the defendants filed, and I think they can be. I think they are severable. I think as long as the Lincoln ordinance stands on its own with its unreasonable, which was given a lot of discussion, and that's where the court went so far to say, well, maybe the city's right about that. And yes, I am saying that they are severable. And the case, and Chief Justice Nuss asked what case, the case that says of any application, Your Honor, I didn't come up with it right away, but that's in our brief. And I believe it's the Boyle case that's cited in the brief. And it emphasizes that if there is any valid application, and I know counsel likes to make a big thing about that, but or makes it a separate application. And I believe, Your Honor, in answer to your question, yes, it can be separated and ignored, the words that you feel are, but there's nothing stronger than injure, there's nothing stronger than endanger, there's nothing stronger than health, and these are all objective standards that are included in the Lincoln ordinance.
And we know they're objective. Why? I mean, I could say I was injured as compared to someone else. I mean, there is some subjectivity to that. It just says, or of others. Someone can claim to have been injured by the noise, where a reasonable person would say that's no louder than a car stereo.
Your Honor, in this case, we did have people injured. They were driven from their home from the noise. And they sought medical help because of noise and dust. And this is why it was investigated by the law enforcement. It wasn't a complaint brought in by an individual citizen.
Any further questions? Thank you, Counsel.
Thank you very much, Your Honors.
May it please the court, my name is David Traster. I'm with the law firm of Philston Seifert in Wichita. I represent Farmway in this case.
And you would agree that we're charged with the responsibility of making every attempt to construe an ordinance or a statute constitutionally?
Yes, Your Honor, I would.
On this noise ordinance, if we simply construe it the term others to mean a reasonable person, why doesn't that solve the problem of
All
vagueness?
right, I absolutely concede that you have the duty, the obligation to try to find a way to make this constitutional, but that isn't, the problem here from my perspective is that the city is asking you to take that particular rule of construction in isolation from also the obligation to read the statute as a whole, to apply the intent for which the ordinance was enacted, and to construe it strictly because it's a criminal statute. And so when you can't take that, we need to find a way to make this constitutional and ignore the rest of those other standards that I've listed in others. And so I think that it's really clear that the intent in this case is to have a very broad statute. And if you look at the statute or the ordinance itself, it's got section 1, very broad, but then there's another section. And that section says we don't want people with amplification systems in our automobiles to be audible within 50 feet. And so they have this very specific statute in which they address a very specific problem. They start off in section 2 of the ordinance with, we don't want to limit anything we've done in section 1, but with respect to amplification systems in automobiles. And then they define amplification system, and then they define audible, clearly audible. And so they know how to define or to draft a narrowly crafted ordinance. But in this case, they wanted to keep their very broadly worded ordinance that has 3 sort of menus that you select from. First, you select from 5 verbs: make, continue to make, maintain, cause, or continue a noise. Then it can be either excessive or unnecessary or unreasonable or unusually loud. Then you have to do one of 8 other things: annoy, disrupt, injure, endanger, comfort, repose, etc. And so I think that it's very clear that you have to take the statute as written, you have to look for what it is that the council intended. They clearly intended to have a broadly worded ordinance. The suggestion that, we don't have to, we'll take care of that in the complaint uses the word annoy. So they want a broadly worded ordinance, and they want to be able to use it to control conduct within the city. Now, I'm not suggesting that the particular city employees and agents, are somehow nefarious or evil here. They're fine people doing fine things, but they need to do it right. And they need to follow the rules. In the Luna case, we're not between Luna. I disagree with Judge Perrin's analysis that we're between Luna and Smith. This is a Luna case. The only difference, the only substantive difference between the Lincoln Ordinance and the Luna case is that they do have one of the menu of options is unreasonable. But the city has asked you in its brief to ignore, to strike, to rewrite the ordinance that the city fathers wrote and seek to apply in this case. I want to make sure, Your Honors, that there's
Council, can we go back to that point just a moment? In looking at Section 1 of the noise ordinance, you mentioned there were 3 different types of menus.
Right.
And one of them included excessive, unnecessary, unreasonable, or unusually loud noise.
Right.
I just want to make sure I understand your point, and as you were attributing it to the city, and that is that most of the other language in Section 1 could be struck as long as we kept the word unreasonable, because that is an objective standard. Did I understand you correctly?
I'm not suggesting it is an objective standard. I'm saying that that's the difference between this ordinance and the ordinance in the city of the Ulysses case.
Right.
But because it is unreasonable noise, that annoys. An unreasonable noise that merely annoys that doesn't fix the statute, in my view. You have to eliminate excessive, unreasonable, and unusually loud in the middle section of the statute, and then you also have to strike annoy and the other vague disrupt. What's that mean?
Well, you're basically getting to my point, which was if you struck enough words in this section, could you make it constitutional? In other words, it would be an unreasonable noise that injures others. Does that save it if we eliminate all these other words?
I don't know what injures means. I suppose that you could, if you say it saves it, it saves it. I mean, but then you'll have to tell us what it means.
Well, I'm asking you.
I know you are.
Let me finish my question,
Sure.
please. Is it appropriate for this court to be striking all these words to leave several words that would make it objective?
I don't think so, Your Honor. I think your obligation is to look for the intent. What is it that they wanted to do based on the words that they used? One of the things.
Well, isn't the chore to look at the ordinance and determine whether it gives fair warning to a reasonable person as to the conduct that's proscribed, so the person can govern their actions to either come within or without, or to govern against arbitrary enforcement? That's what we've said vagueness involves.
Absolutely. Yes.
And if there are words in there that would be objectively reasonable or should be objectively understood, why isn't that fair warning, even though there are some superfluous vagueness in there? You understand what I'm saying?
Yes, I think I do. In this case, in essence, the city, in my view, could, at trial, if they prove that we continue to make an unreasonable noise that endangers health. I mean, I don't know what endangers health means, but you might be able to make the argument that but we are at risk for being penalized criminally if the city would make.
I understand. That's a different thing. But your client looks at this ordinance,
right,
and then will govern its conduct based on the ordinance. And why don't some of those words dictate or at least advise your client what can and cannot be done with regard to noise?
Because if we make any unnecessary noise that annoys somebody, we're in violation. There's no way for us to comply.
I'm sorry. Why don't you finish your sentence?
Well, there's no way for us to, if I'm not capable, I suppose you have the authority to rewrite the ordinance for the city, which is in essence what I guess they're inviting you to do. But, I mean, I guess you need to probably tell them okay, this is what it is, and I mean, if I go read the ordinance, do I have to go read your case too? I mean, this is the ordinance that puts people on notice of what's needed, or how to govern their conduct, and it says if I make an unnecessary noise that annoys somebody, I'm guilty. I mean, is whispering in a theater, is about when you're getting ready to putt and I start talking, it's unnecessary and it's very annoying. It violates the statute, the plain terms of the statute as written, as the city wrote it.
Where I was going with my question, I think Justice Johnson has turned it slightly.
Sure.
But it's still a good question from him, as I understand it, and that is, if one of our tests is to see if a reasonable person could understand from reading this ordinance what was illegal, there appears to be, by pulling out a few words, that your client would be informed that it is unlawful if you are making an unreasonable noise that endangers the health of others within the city. And so my question is, does this put your client on sufficient notice that that alone is unlawful? It's an unreasonable noise, and it injures or endangers the health of others in the city.
If it stopped there, maybe. I mean, this court in 180 Kansas, I've got the site, said that it's impossible to define the word public health, and this is the language used in the nuisance statute, but it's impossible to define public health. And so, if you endanger public health,
let's talk about endangering the safety.
Yeah. Well,
the question is there nothing in this ordinance that would tell your client, even a small part of it, that, hey, this is clearly illegal in the city?
There are some things that may be clearly illegal, but there are so many other things that aren't. I mean,
Isn't that more of an overbreadth argument than a vagueness argument? That's what I'm struggling with as I'm sitting here listening to you. For example, your two samples of whispering during a movie. Everybody hates that, right?
No.
It's annoying. It's annoying.
Right.
It's unnecessary. Same thing with talking while somebody's putting, although I got to admit golf is beyond me. So those two examples, you look at the plain wording of the statute, that's illegal conduct. Right?
Right.
But that's not a vagueness problem, that's an overbreadth problem, right?
Well, maybe.
Yeah.
The problem is, I suppose so, I mean, the problem is that you have, when you are looking at the statute, and you're asking what conduct is, there is no objective standard. There are, I mean, none of these terms, my position, none of these terms are really very clear. But clearly, you violate the statute by annoying. Yes, I guess, Your Honor, that would be true. It is an overbreadth argument. But it's also vagueness in the sense that we've been charged with annoying. That language is in the complaint. Those are facts that are before the court. Here's the complaint. This is what they charged us with.
Is there any way that a community or a city or a town can enact a statute that is general? I mean, does it have to be so specific as what you said, operating amplified music within 50 feet? Does it have to, where can a city or municipality adopt a general noise ordinance, and how would they do that?
Read Smith versus City of Wichita, and it says a reasonable person standard. It imposes a reasonable person standard. That ordinance also has decibel limits and
so it has to, in your mind, it has to be the reasonable test has to be specific as opposed to a general type of noise or a general type of...
No, I think the City of Wichita ordinance, as reflected in Smith versus Wichita, or Wichita versus, says the noise, it's illegal to make a noise that is whatever the terms are to a person with reasonable sensibilities. They added that in. That way, the problem, of course, is that some people are very annoyed by whispering in the theater, and some people whisper in the theater, so obviously aren't annoyed. But I've sat in the theater and been annoyed, but I'm pretty sensitive about that, frankly. I don't like it at all. So, does it violate? It's a reasonable person standard. We know what that means.
Well, use it in the perspective of Lincoln, a farming community. I mean, I guarantee you there's some farmers that live near the elevator that it doesn't annoy them at all because it's their grain that's being kept cool and that they're going to be able to sell down the road because it's being kept cool by the noisy fans.
Right.
Is that a person of reasonable sensitivity?
Well, that's...
Not necessarily.
I understand.
That's what causes the problem in Lincoln.
I understand that, and this is one of the other issues here is how important this industry is. I mean, this is an essential activity.
And we aren't talking about zoning ordinances.
Right, which they could have done.
We're talking about a criminal conviction.
Exactly.
Talking about convicting someone of a crime.
Right.
Based on general terms.
Exactly right, Your Honor. Exactly right. I mean, your point is a good one. But at least there's you can go to the jury and you can say, okay, person of reasonable sensitivities. You might not get perfect agreement on what that is, but at least they know what standard to apply. At least there is a standard.
Why can it not be subjective if there's actual harm? If a person's health is injured, if the safety is injured, how is that any different than phrasing it in terms of public health and safety?
Well, so what you're asking is if I'm on notice that how do you charge that, though? I mean, the allegation is still, if you had a police officer who said, well, in my view, there's actual physical harm. I mean, I guess that's, I don't know. I'm not sure how to respond to that, Your Honor. At this point, what we're really dealing with are allegations, and so we don't. We have an opportunity. Many of them, by the way, if you read that the municipal court's opinion, I mean there are at least 8 instances of facts or issues that were post-complaint evidence. I mean, the evidence in this case has a lot to do with what happened after the complaint was filed. There are 8 instances I counted, including every one of the 51 signatures or 52 signatures on this petition were dated after the complaint. So, I mean, there's some fundamental problems with the way this case has come up.
But by the same token, and you're touching on something that's been bothering me on this one, which is, this isn't a situation where your client suddenly had, the local sheriff walk in and say, here's this criminal violation. I mean, you got a problem. You expanded this grain elevator by 75%. You've got this noise level. Even your own guy, I think is it O'Bannon, says it's excessive noise from where he lives.
He said it was loud.
The finding on the municipal court is that it was excessive noise. And so, I mean, this doesn't come as a surprise that you're really, really bothering the neighbors. I'm not trying to use the word nuisance right now, but you're taking steps to try to deal with it. So, you're not just going, you're really taking steps So it's hard to see in this case how you know this is something more than just annoying the neighbors. You know your neighbors